All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so Phil, we're going to chat about a few things kind of all related today. We're going to be focusing on the Pregnant Workers Fairness Act, and that's going to take us into a little bit deeper discussion about the EEOC and its regulatory agenda and some of its personnel that we're going to become familiar with over the course of the next year as we ramp up toward to a new election. So interestingly, on Tuesday of this week, a United States District Judge in Texas held that the EEOC and the United States Department of Justice cannot take steps to enforce the Pregnant Workers Fairness Act against Texas or state agencies, since the omnibus spending package that the law was attached to was approved in late 2022 without a proper quorum in the House of Representatives. Okay,
so maybe a technicality, maybe there might be. Hey, but just remind us real quickly what the Pregnant Workers Fairness Act is, if anyone's listening and not aware, please.
Yep. Sure. So last year in I think it was June or July, a new law went into effect called the Pregnant Workers Fairness Act, and what that law did was it bolstered legal protections for workers who are pregnant or have conditions tied to pregnancy and childbirth by requiring employers to offer reasonable accommodations to help those folks on the job. So the EEOC began accepting Pregnant Workers Fairness Act charges. Actually, it was last June when it took effect. And so since then, that has been a protected category. Pregnancy has been a protected category in and of itself, enforced by the EEOC. And people could bring charges of discrimination. So this judge, in a 120-page order, basically said that when the House passed its $1.7 trillion Consolidated Appropriations Act of 2023, it used a pandemic-era rule that allowed lawmakers to vote remotely by proxy. Texas had filed suit in February of 2023, claiming that the spending package violated the Constitution's quorum law, and the judge agreed. So again, for right now, confusion in Texas on whether the Pregnant Workers Fairness Act is actually enforceable. I don't think that this is going to have broader appeal beyond Texas right now, because the judge did not invalidate the law nationwide, just did it in Texas. And I do think that this one will be appealed. So
yeah, that's gonna be interesting to see that. I mean, and it gets back to what we're gonna chat with Fred about when you're talking about, like, I mean, in my mind, I'm like, okay, look, if a lady is pregnant and she needs some assistance and accommodation, it just seems like the right thing to do. The fact that we have to have a law for that. I know there's abuse, and I know we have all those scenarios, and that's why we have laws and policies and all these different things, but it just almost seems a little bit ridiculous. I don't know if you have an opinion in that space, Bert. I know you're going to just reflect the law, but
no,
I this going, all right, come on. If someone needs some help, my mother taught me to be a gentleman. Let's help them out.
Yeah, I think that that's right, Phil. But I think even more fundamentally, the law sort of already protected women in the workplace who had a pregnancy-related condition that needed some sort of assistance or accommodation, either under the gender discrimination laws or the Americans with Disabilities Act. I think that I think that protections already existed, but to the extent any employer was out there not making accommodations under the laws that already existed, this one sort of layered on top of it.
Okay, so hey, sir, that's great. Thank you. And I'm going to throw you a curveball, and I don't mean to do this, but I'm wondering if you can see the chat. We have a question here from Laura, and it pertains to our program last couple of weeks. She basically, they have a vendor or cleaning service that comes to clean at least once a week. They are an actual business with insurance. We advise which day works best for us. However, the owner will schedule what time her employees will show up to work. We agreed to provide the cleaning supplies. Is this an issue with the new laws regarding independent contractor?
So probably not going to be an issue.
I wouldn't think so either. Yeah.
It depends on, Laura, I'm not quite sure what your company does, but I assume your company is not in the business of cleaning. And so that this is truly somebody, a company that's coming in to do cleaning that's not part of your ordinary business. And then very importantly, the cleaning vendor that's cleaning your facility, I presume that cleaning vendor is actually a real business that you say in your comment here, they are an actual business with insurance, and importantly, presumably they clean other facilities of other companies
That's
as
where I
well.
was going to go to. Right. If they're only working for your organization 1 day a week and that you're using, well, they have their own insurance, that probably isn't going to muster the cut.
Yes, there you
Yeah.
go.
Yeah. All right.
All right.
Back to you, Bert. I
All
hope
right.
that helps you out, Laura.
All right, so then I want to shift gears since we're kind of talking about the EEOC anyway, related to the Pregnant Workers Fairness Act. The EEOC late last year had come out with its regulatory agenda for 2024. And one of the main pieces of its regulatory agenda was the enforcement and the proposed rule implementing the Pregnant Workers Fairness Act. And the agency expected the agency expected to have drafted that rule. That act went into place again June 2023, and it requires employers with 15 or more employees to provide reasonable accommodations to current and prospective employees with no limitations stemming from pregnancy, childbirth, or related medical conditions. Now, it's really interesting because, again, similar to the ADA, the employer does not have to provide those accommodations if those accommodations would constitute an undue hardship. And like I said, this new law is kind of layered on top of Title VII of the Civil Rights Act of 1964 and the Americans with Disabilities Act, and it may expand some of the accommodations that employers need to make for pregnant workers. And some of those might include things like allowing pregnant workers to have water or food in the workplace, reducing their lifting requirements, providing pregnant workers the ability to sit, allowing them additional breaks to use the bathroom, eat, and rest, and excusing them from activities that involve exposure to compounds unsafe for pregnancy. And then finally, providing them with appropriately sized uniforms and safety apparel. So that's where the EEOC is going with the Pregnant Workers Fairness Act. I want to make it very clear that employers, most employers, and if I've counseled you on this in the past, I've sort of already analyzed these types of issues under the ADA and Title VII to existing laws, but I want to make it clear that this does layer on top. And then real quickly, Phil, just a little bit more on the EEOC. I do want to chat a little bit, since their regulatory agenda is starting to get more attention. And one of the reasons for that is that back in August of last year, the EEOC finally got a full commission. They finally filled all 5 seats on the commission. And very importantly, the first time during the Obama administration that the Democrats actually had a majority on the commission during the Biden administration. And if you recall, I warned everybody that as soon as they became the majority on the EEOC, and it had to do with the expiration of the staggered terms of the EEOC commissioners, but as soon as they got the Democrat majority, watch out, the EEOC was going to get much more active. So last year on August 9th, Kalpana Kodagal became the 5th EEOC commissioner. By the way, she's going to be one of our guests and keynote speakers at Ogletree's Workplace Strategy Seminar, which is the first week in May of this year in Washington, D.C. She's joining us as one of the keynote speakers. Now, she was a civil rights and employment rights lawyer who practiced at what I would call plaintiff side employment firm, doing sort of the opposite of what I do. And then last year, also in October, the Senate confirmed Carla Gilbride as the EEOC's general counsel. Now, she's really got a fascinating background. She clerked at the Ninth Circuit for a judge in the Court of Appeals over there. And she also was a co-director of a project called the Access to Justice Project at a nonprofit organization. She argued a case in 2022 in front of the U.S. Supreme Court Now she's blind, and she is thought to be the first person first blind attorney who's ever argued before the U.S. Supreme Court. Now, she has been pretty quiet since she's gotten her position, but just this week, she called out and said that the damage caps under Title VII and of the Civil Rights Act and other laws that the EEOC enforces, she called those morally unacceptable. So a lot of people don't realize that companies with between 15 and 100 employees won't pay any more than $50,000 in compensatory and punitive damages if they're found to have violated the laws. For employers with between 101 and 200 people, compensatory and punitive damages are capped at $100,000. For employers with 201 to 500 workers, it's capped at $200,000. And for employers that have more than 500 workers, those damages are capped at $300,000. So sometimes we see these large verdicts, millions of dollars, and those verdicts get reduced substantially if they're brought just under federal law. We're taking state law out of the analysis right now. And this included a verdict last year. For example, there was a $36 million verdict that the EEOC won last year on behalf of a deaf applicant who was denied a truck driving position. And the ultimate award was $335,000, factoring in $35,000 for back pay. And so she again calls these damage caps morally unacceptable. And now the EEOC, interestingly, they don't have any authority or ability to change these damage caps. That would take a new law passed by Congress or an amendment of an existing law passed by Congress. But it does show you the EEOC's sort of priority in their thinking when it comes to damages and sort of their aggressiveness going after employers. So, and I think the flip side is well, let me say also that these damage caps were put in place back in 1991, and they have not been raised. And I do think she's got an argument there that perhaps they do need to be revisited at some point. But what the damage caps were designed to do was to prevent employment law litigation from turning into bet the company litigation, especially when you have employees who might be suing en masse, class actions, collective actions, those types of things, and also making sure that you have employees that are $20,000, $30,000 a year employees can't turn around and take a company down completely because they get a huge verdict. So that's sort of the flip side of it.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.